limitations. The plaintiffs failed to meet their burden of proof in on this claim, showing that, in fact, the men in the department in which they teach as a group were paid more than the women as a group. As a bit of background, these two women teach in what's called the technical division of the Tantasqua Regional High School.
Can I ask you a question about your first point?
Certainly.
Which statute of limitations are you talking about?
Well, the judge seems to have applied a modified continuing violation type of statute of limitation. It's the defendant's position that a more traditional statute of limitation indeed applies in this case.
And which would that be?
That would be the 6-month statute of limitations of time to file at the MCAD.
All right, but this case wasn't resolved at the MCAD.
No, the plaintiffs removed this case to the Superior Court.
So the statutory statute of limitations is 1 year.
The statutory statute of limitations is 1 year.
And I notice you don't really argue that in your brief.
That was not, at the trial, all parties were going forward on the assumption based on, I believe, the Jancy case that, in fact, the plaintiffs needed to file this claim in the MCAD before they proceeded to Superior Court.
But what's that got to do with the statutory 1 year statute of limitations? There are two statutes that apply.
Yes.
So why didn't you, have you waived the argument under the 1 year statute?
We didn't raise it below, so we did not raise it here. I know that the amicus brief raised the 1 year.
The amicus brief waived it fairly directly.
Yes, they did. In fact, though, the Jancy court, I believe the reason plaintiffs' counsel, I, and the trial judge were relying on what was in the Jancy decision, which specifically said that in an unequal pay claim, the plaintiffs still had to bring their claim at the MCAD within the 6 months.
And if they file it in the Superior Court, they have to comply with both statutes, right?
Yes, they do.
Right. All right, so tell me this. It seems to me, I understand your point that as of September 1998, the plaintiffs surely believed they had been discriminated against in their pay. Absolutely. They wrote a letter to that effect.
They did.
And why wasn't that the beginning of a grievance procedure under the union contract, which would have told the 6-month statute of limitations?
Even if that was a grievance procedure, the meeting that the plaintiffs had with the superintendent, at which the superintendent referred to that meeting at trial as the level 2 grievance hearing, that meeting was in November of 1998. And within the collective bargaining agreement, which is in the appendix, specifically lays out the timetable in which all this has to happen. And the superintendent did not allow the grievance within 10 days of that meeting. And at that point, certainly the plaintiffs should have known that they would not have gotten relief through the grievance procedure, and any tolling should have ended at that point.
So tell me exactly when the tolling ended. If this were a grievance procedure, and I noticed that one of the plaintiffs, her testimony is that it wasn't a grievance procedure, so I'm still confused about this. But under the theory that it was a grievance procedure, when did it end? In
November of 1998.
November, and that's clear from the record?
Yes.
And so what does the MCAD regulation say about the tolling period?
In terms of
after the grievance, is it 6 months after the grievance is over, or is it 6 months after, or something else?
I don't know that answer, but even given the benefit of the doubt, if it's 6 months after the tolling period is over, the plaintiff still did not file within 6 months of November of 1998. Okay. They did not file until July of 1998.
Thank you. 1999.
I'm sorry, July of 1999. The judge here seemed to apply sort of a modified continuing violation and went on to say that until the school district provided the union and the school teachers with documentary information about their claim, that the statute of limitations was in fact told until that date. He did that without any support. There's no basis for that. There's no requirement that a defendant supply a plaintiff with the documentary evidence that they may need in order to bring their claim, especially in light of the letter that the plaintiff had written.
How else in an equal pay claim are you going to be able to do that? In other words, you have a suspicion. I mean, one of the problems with equal pay claims is it's very hard to determine what other employees are earning. They may not choose to tell you. It is the kind of information that employers classically keep most confidential. The right to know what other people are earning is often not established. It seems to me at least one of the things that the judge was saying here was they go through a grievance procedure and they really still don't know. In April of 1999, up until that point they had suspicions of discrimination, but they didn't have any confirmation. What I'm trying to think of is assume that they filed, in November 1998. What's the proof? You file a motion to dismiss, right? You file a motion to dismiss.
And I assume in opposition to that motion to dismiss would be affidavits of the plaintiffs and the people
but
that they spoke with.
They don't know. They only have a suspicion. And then they say, Judge, please stay this so that we can take discovery. And the employer says, this is a fishing expedition. They've got no real basis. They have suspicion.
I assume if they come forward with affidavit testimony from fellow employees that say, we're making this much, this is what we're making, this is what the plaintiffs are making.
Well, didn't they have that in this case? I thought the whole basis of this was a discussion between one or both of the plaintiffs and their co-employees who were male, saying they got more credit for their starting salary than the two plaintiffs did.
That was the basis of their claim. This case may be slightly different than most equal pay cases because these two plaintiffs, in fact, worked for a public employer. All of the information that these plaintiffs needed to show whether or not they, in fact, had an equal pay claim were available to them from the time that they were first employed through a public records request. So this, in fact, may be slightly different than the type of case in which someone works for a private employer where that information is, in fact, held confidential.
What's the information they would have got on a FOIA request?
They could have requested all of the starting contracts of each teacher in the division, which has specifically on the contract.
Would they have been entitled to each curriculum vitae in the personnel file?
I don't know if they would be entitled to that.
I can tell you the answer to that is no. And if the claim is that they were getting credit, what I'm trying to do is to look to see what the I think what the judge was doing was struggling with a not very unusual set of circumstances. They had to wait until they had confirmation.
And even if they had to wait until they had confirmation, you then have to look what is the extent of their claim within the statute of limitations. And here the judge said the plaintiffs did not receive the information they needed to substantiate their claim until April of 1998, so the statute did not start running until then. But once the plaintiffs got that information, if you're going to go on a continuing violation theory, the next question becomes, was there a discriminatory event within the 6 months of the plaintiffs filing their claim? In this instance, was there an unequal paycheck in that 6-month period starting in July of 1999 and going back the 6 months? And for Ms. Silvestris, the answer clearly is no. The maximum pay level in this school district is referred to as Step 10. And Ms. Silvestris had reached the maximum pay level several years before she brought her unequal pay claim. So even if...
But why isn't this... I mean, forget continuing violation for a moment, because that carries with it a lot of baggage. Mm-hmm. Just think of this as a civil claim. Generally, the statute doesn't begin to run until you're reasonably on notice of the claim. And once you are, then you have whatever it is, 6 months, a year, whatever the applicable statute is, to bring the claim. But the claim, let's assume the plaintiffs did not know that starting in 1993 and 1995 they had been getting unequal pay. The statute with respect to all of that only began to run when they were on notice of it. Why isn't this an ordinary civil claim? So once they file within the tolling period, once they're on notice, they can get damages for the entire harm that they suffered.
Well, if if this is in fact an ordinary claim, I would argue, Your Honor, that the letter that the plaintiffs wrote in September of 1998, the language that they used in that letter said, we believe discrimination has occurred. And under a traditional analysis of the statute of limitations, that is in fact a reasonable belief which triggers...
Well, I may agree with you on that, or maybe not. I don't know. We'll hear from counsel on the other side. But you're making a second argument, was even if it was timely filed, that means that even if it was filed within 6 months of when they were on reasonable notice, that they should only collect for 6 months, even though the damage upon which they are now aware goes back to when they were hired, because actually that's when the discriminatory acts occurred.
This is where I think the federal statute, which is not exactly the same as the Massachusetts statute, may in fact be instructive. The federal statute is much more clear in terms of recognizing that the paychecks themselves may be discriminatory events that continue forward, but the federal statute has a built-in going back time, if you will, as long as there is a discriminatory paycheck within the time frame.
Mr. Lucia, I don't think the federal courts have said if you are discriminated at this point and you end up catching up because you happen to have an employer that happens to have a ceiling, right? Many employers, you just keep going up with cost of livings, and so if you started off at a discriminated level, you're going to end up 5 years later at a discriminated level. You happen to represent an employer that has, like many employers, especially in the public sector, a ceiling. Once you get up there, you bump. And in fact, unless you can be reclassified so that you're in a different grade, and maybe these people could or couldn't, eventually, even if you started off being discriminated against, I mean, I don't think that there's any federal case that says that will bar any claims of discrimination.
I don't believe there's a federal case that says that will bar, but there's not one saying the other. The federal cases seem fairly clear that they look to the two, going back 2 years.
Discrimination continues. Let me ask you this. Did you argue below that the letter that they wrote constituted, for statute of limitations purposes, they knew or should have known? Did you make that argument?
Yes, I did.
They didn't know, correct?
Their words are, we believe discrimination has occurred.
No, but they didn't know, correct?
They did not have the documentary evidence.
And did you make the argument that FOIA would have given them the information?
I believe that I did.
Okay. And FOIA would have given you perhaps what the rate of pay was, correct, for the individual?
It certainly would have given you what FOIA would have given you is the step at which the teachers started at. These teachers had the collective bargaining agreement, which has the chart of the rate of pay.
Would FOIA have given what the CV was that would identify particular people, which will tell you how much credit was being given for whatever it was?
I do not believe that FOIA necessarily would have given that
it doesn't.
information.
How would they have known if they had received the information from FOIA?
If they claim to have spoken with fellow teachers who they worked with every day, who told them how much experience or how much work experience they had in the particular field they were in, that coupled with an actual knowing in that instance what the pay step was, would have given them certainly a reasonable belief, or further supported their reasonable belief as to whether or not they were receiving less credit than their male counterparts.
And one of the claims that the employer makes is actually you can't look at individual men or individual women. You've got to look across the whole group, correct?
Absolutely.
And so they couldn't have obtained that information. They asked for the information. The employer says, I'm not going to give you the information. And then you say they knew or should have known.
Well, here they didn't even ask for the information. If they had that belief or had at any point wanted to know where do I fall, where do the women in this group fall compared to the men in this group, they could have in fact made that request and have known it much sooner in time.
Can I ask you this? What did the plaintiffs get in April that they could not have gotten under a FOIA request?
I believe nothing. What they got in April were the contracts of each of the teachers who were teaching.
So they didn't get the CV. They didn't get the CVs of each of these other teachers in April.
I don't believe they got that in April. No.
Okay. Thank you.
Can I just ask you one other question? With respect to the judge's damages information, that came from where?
In terms of the calculation of damages,
Your actual salary level 3 difference.
the salary level at which the plaintiffs were originally paid at the testimony of the plaintiffs as well as their contracts, the salary level at which other teachers were paid at came in through the initial contracts of the various teachers and testimony of the superintendents as in terms of the experience and the interview process, as well as the CV of some of the teachers in the technical division. I don't believe all of the CVs came in.
Well, but the damages, I take it, were calculated by the judge saying, this is all very subjective, and the superintendent obviously has discretion, but I'm going to put them at the top of the pyramid as their base starting salary,
Yes.
and calculate from there.
That's what he did.
Yeah.
And it's the school district's argument that there was not evidence to support putting these two teachers at the top of the pay step in their first year of teaching in this school system.
Thank you, Mr. Lucia. Mr. Moriarty?
Thank you, Your Honor. May it please the court, I'm C.J. Moriarty, and I represent the plaintiffs, Joanne Silvestris and Valerie Gonzalez, who are the appellees here in this case.
I'd like to ask you the same question that Justice Cordy just asked your adversary. What did the plaintiffs get in April that they couldn't have gotten under a FOIA request earlier?
Well, Your Honor, I don't know what they would have gotten under a FOIA request. I can tell you that what they got in April was only half the information that they had requested, and which had been denied them for a substantial period of time. And it was as a result of that they then filed a complaint with the MCAD.
But in April they felt they had enough information to file a claim.
In April they did, but part of that, Your Honor, was also the fact that the other information was not forthcoming. In fact, they believed that they were being stonewalled, which is why they filed at that time, 2.5 months after they got that information, with the MCAD. They did not get, Judge, and it appears in, you'll see the roster that's in the transcript. They received the grade level that each of the male teachers had when they were hired, but they didn't receive any information with respect to what their prior year's experience had been. So it was containing basically half the information.
But Defendant's Counsel stated, I believe, that the plaintiffs had that information from discussions with their male counterparts.
The only discussion they had, the only information they had, Your Honor, which was as a result of basically anecdotal lunchroom chatter, was that one male particularly, a Gary Manuel, had received credit for work experience. When both of these females were hired, when both of these women were hired, they were told they were not being given credit for real-life work experience. That turned out to be a lie.
It did, because they were given credit for experience.
No, Your Honor.
That's the way I read the record. They didn't get this credit simply from teaching experience.
Your Honor, let me break it down for you. Ms. Silvestris had 5 years of teaching experience and many years of work experience. She started at level 6, being given credit for the 5 years experience. Now, the record also showed that Ms. Gonzalez, who had 1 year...
Five years of relevant teaching experience?
Yes, Your Honor, she did.
Where?
At the Westover Job Corps, where she trained as a nurse, and at the Holyoke Community College. And they gave her credit for those 5 years. And as she testified, and as the judge credited in his findings, she was told they would not be given, she wouldn't be given, because she was hired first, credit for work-life experience. Now, I agree that the situation with Ms. Gonzalez is a little bit different, but the fact of the matter is this: if you read the entire transcript, it comes clear. What happened with Ms. Gonzalez is that when she was hired, when she was first offered the job, and she had 20 years work experience, she was told, and 1 year teaching, she was told you get no credit for work-life experience, and she was offered the position at the base level, the entry level. She turned that down. It turned out that there were only 5 applicants for this position, and her application was the only one that met the requirements of the Department of Education. That appears in the transcript. So she was the only one who could be hired. So she was given a salary where she was given credit. She said she wanted $30,000, so she was basically put at that level.
Well, this is very consistent with what the judge found, that this really wasn't discriminate. The way salaries were set within these ranges, because the bargaining agreement set the ranges where people had to come in at different points. But the seniority and how the superintendent decided to credit seniority for purposes of where they came within the pyramid, the judge found it was sort of arbitrary and depended on how much money the school district had and what it would take to get this person on board. And as it turns out, the court finds your two clients got the short end of the stick, but not because of any intent to discriminate against them. Simply the various factors that went into trying to strike the best deal you could with vocational teachers.
That's correct, Judge, and that's why he found against us on the 151B claim, because there was no intentional. But the equal wage claim does not require intentional. I believe, as the court has found in Jancy, it's a strict liability case. And the fact of the matter was proven, is that Ms. Silvestris did not receive any credit for her work experience, and Ms. Gonsalves far less than the males.
Than all the males?
Than all the males?
Yeah.
I can't say for all the males.
There's a chart on page 25 of the, is it on page 25 of the town's brief that has all of the employees here. Is that chart accurate, by the way?
I wouldn't say that it
has teaching experience starting with every employee.
Or was it an exhibit?
That was not an exhibit.
So this is argument.
This is argument, and I don't have the council's brief in front of me, but I believe I took exception to that chart in my brief, where I said that they're putting a different factor. They talk about public school experience. There's no such requirement in the collective bargaining agreement or anyway. So I think that that's a.
I took it that this was not an exhibit, that you've raised, at least as I recall, raised a question about it, and
that was not an exhibit, Your Honor, what was put there. That was an argument, a compilation of argument by counsel.
Well, can I ask you this? Now, you've got, for example, you've got Ms. Bullock, female, no teaching experience, 3 years work experience, gets step 4, the same place where one of your clients started. Right? So she was given full credit for all of her work experience.
What does
3 years.
What does post-college mean? Post-college. There's a little thing there. I mean, I literally couldn't. It says post-college. I don't know what that is.
I don't know what they were referring to, but that's in the appellant's brief. I point out, Judge, that there were many men who were given much more credit. I direct your attention to Morris Bracken. He had 6 years in the field. He was given 3 years credit, 2 for 1.
Bracken?
Mr. Bracken.
All right, this says 16 years. I don't know what's, again, you've got it. I just got this chart in front of me. If it's wrong, it says here he had 16 years of experience and he got 3 years credit.
Mr. Delolio, Your Honor, he's another one. 7 and 7. He was placed at level 9.
Right. 7 years teaching.
7 years experience.
7 years teaching. That's pretty solid, creditable experience, you would think.
It is. Mr. Drexage had 0 years of experience. He was placed at a level 9.
26 and a half years of work experience. He was a carpenter or something?
He was given credit for it. Far less than my clients were given. And that's what the judge's point was. Also, Your Honor, I think that the court should not ignore...
Let me get to that. So he was given 1/3. How many? He got... So he was given about 1/3 of a year per year of experience.
A little more than 1/3, Your Honor. But approximately. I wouldn't quibble with it.
Where would that put Gonsalves, your client, for example, if she had gotten 1/3?
Would have placed her at perhaps 2/8.
Right. Well, how come? And then why is the judge placing her at 3, jumping her 2 more levels?
You're ignoring some evidence, Your Honor, and the evidence that you're ignoring is the admission of the superintendent that was before the court, who was the superintendent who sets the salary. That, as a general rule of thumb, you get credit for 1 year teaching or 2 years of work experience.
You know, I saw that testimony. She wasn't the one that hired all of these people. Correct?
No, Mr. Roach hired Ms. Silvestris, And he said you didn't get credit at all.
Yeah. And she said 1 for 2. Nobody got 1 for 2. Everybody got less than that. It was either 1 for 6, 1 for 3, 1 for 4, maybe, I don't know. I don't think anybody got 1 for 2. So she may have testified her rule of thumb was, but the evidence in the record is completely inconsistent with that rule of thumb.
Well, we didn't have all of the teachers in front of us, Your Honor, so we don't know for how long that this went down.
Mr. Moriarty, do you happen to know on what basis, I'm turning to the FOIA, the claim that's been made here, that there was an obligation on the plaintiffs to get a FOIA request. Do you happen to know on what frequency the information is filed by the school at a FOIA request?
I have this is the first time that I have ever heard mentioned in any courtroom that the plaintiffs had an obligation to file a Freedom of Information Act request.
Did the employer file a Freedom of Information request and present that evidence to the court to say this was readily available to anybody?
No, they did not. That was never mentioned below.
So we have no idea what would have been provided to them?
I have no idea what would have been provided to them, Your Honor, and the record is barren as what would have been provided to them.
Is there any case that says that what the employee is obligated to do is to go to third parties to obtain information if it brings an Equal Pay Act claim?
If there is, Your Honor, I'm unaware of it.
Well, isn't there a general discovery rule that once you're on notice that you have been harmed in some way, you have some responsibility to diligently pursue that?
I believe they did, Your Honor, and their discovery rule was contained in the collective bargaining agreement, which was admitted as an exhibit in this case.
Mr. Moriarty, I just finished my questions. I understand here, are you saying that the school never raised a FOIA argument below?
They never raised it, Judge.
Did they proffer reasons why they believe that the plaintiffs knew or should have known?
They hang their hat on...
No, I'm talking about at trial.
At
trial.
At trial.
In the Superior Court.
The issue that was raised, and this was the only issue that was raised with respect to the statute of limitations, was that it should have been filed within 6 months of the September letter. And the September letter, I believe, was dated.
I understand that. I'm trying to find out what argument they made to this judge as to what these plaintiffs knew or should have known at that time.
The only argument that I can recall being made is that because of the letter, they believed that discrimination had occurred. The judge specifically found that they didn't have the documentation to proceed, and that they tried to obtain it through filing a grievance, through meetings with the superintendent, were stonewalled until April, until they finally received half the information. And then when they received it, their suspicions were confirmed. So they did file a grievance.
Was it a statute?
Yes, Your Honor, they did.
Was the statute of limitations asserted as an affirmative defense?
The only statute, yes, the statute of limitations.
And who had the burden to prove that?
Pardon me?
And who had the burden to prove that?
Did I have the burden to prove it?
Who had the burden?
Well, I believe that the burden of proof as to proving a violation of the statute of limitations probably rests with the defendant, because it's an affirmative defense, but I think we have to prove that we filed it.
No, I understand that, but I'm trying to ascertain what evidence they came forward, with which they came forward, that, in other words, it is possible, I don't know whether there's an obligation on somebody to go to a third party, but let's assume that there is. I would have thought the school could have filed a FOIA request and said, this is what you could have got. You knew or should have known. I'm trying to, as I understand your statement this morning, the only thing they pointed to prove that the statute of limitations was told as of September was that letter, correct?
That's correct, Your Honor. The first time I've heard of a Freedom of Information Act request was this morning. I've never heard that before. I would like to just comment on the complaint, on the defendant's position that the damages should be limited to 6 months. That was never argued below. That was never argued below at all. The only time it was raised as an issue was on appeal in the appellant's brief. I direct the court's attention to the fact that this was a bifurcated trial. There was an issue in liability, and then there was an issue in damages. And the trial judge below specifically asked trial counsel for the defendant below what your argument was. And at no point did they make this argument should be limited to 6 months. In fact, they argued it completely different. If you look at the...
What was the argument to the trial judge?
The argument to the trial judge was they weren't entitled to any damages because we hadn't proved that there was a violation of the Equal Pay Act claim. As a matter of fact, I direct the court's attention to page 525 of the transcript, where Judge Carhart asked defense counsel, so it's all or nothing then? And there was no reply. Now, I also suggest to you, if you look at the pleadings in this case, that there was a motion to reduce the award to Valerie Gonsalves. That motion asked for reduction in damages from $59,000 to $47,000. There was never any suggestion until this brief was filed that damages should be limited to a 6-month period.
Counsel, can I come back to this letter? I've got it in front of me. It's a fairly persuasive letter about why they believe they were discriminated against. At the end, it says, we believe that discrimination has occurred and restitution is necessary. And we hope our union president will assist us in remedying this injustice. You say this began a grievance.
It did.
Why is your client, the person who signed this letter, testify that she did not initiate a grievance on this? Is that just a misunderstanding?
I think it is, and okay. Frankly, Your Honor, the superintendent, according to her testimony, treated it as a grievance.
And I think that's right. So I'm wondering, when did the grievance period end under the contract?
Well, the grievance really never ended because as they went through the process, as the transcript of Ms. Silvestris' testimony makes clear, is that she was looking for information.
And when did the grievance end? Did the superintendent deny the...
There was never any denial. There was never any affirmative denial. When they didn't get the information in April and it had not been forthcoming, when they felt they were stonewalled, they filed 2.5 months after that.
So your argument, contrary to your sister, is that the grievance never ended. There was no decision of the superintendent to reject the claim.
The superintendent never issued a...
That's not in her testimony. I mean...
I don't recall that, her ever testifying to that, Your Honor.
The only testimony about this being a grievance process is the superintendent who said she viewed it as a grievance process. Your client said it wasn't a grievance.
Well, that's correct. She was basically, but I would also, she phrased it in the nature of an inquiry. But if you look at the procedure that was followed, to follow the grievance procedure, you have to write to the school principal or union head, which is what she did.
Right, exactly.
Thank you, Mr. Murray.
Thank you.